Hello and welcome to Fortifying Healthcare IT Strategies to Protect Your Organization from Rising Class Action Lawsuits. Here are a few things you should know. If you can see my lips moving but you can't hear me, it's because Livestorm begins all of our webinars with your sound on mute. So if you can't hear us, click on the screen to turn on the sound. Your microphone will remain muted, but please use the chat to talk to us. In fact, tell us where you're dialing in from today. If the alerts are too much, you can mute them by clicking on the bell on the right-hand side. And please note, you will automatically get a recording, but if you would like the presentation slides, please email ellie.miller@criticalInsight.com. I will be sharing that email as well inside of the chat messages that you have here. Today, we are excited to have several speakers with us. Starting out, Aravind Swaminathan helps clients navigate a new world of regulatory risk, from cybersecurity incidents to online trust and safety to defending executives in high-stakes litigation and enforcement actions. His deep knowledge of his clients' business objectives and technological capabilities distinguishes him as a strategic advisor and frontline crisis responder. He advises some of the world's leading online platforms, public and private financial institutions, tech companies, higher education institutions, and critical infrastructure providers on cybersecurity and their obligations to monitor and remove harmful or illegal content online and root out instances of child exploitation. He is adept at guiding companies through cybersecurity incidents, having directed more than 500 data breach investigations, including enterprise-wide network intrusions to cyber attacks with national security implications. Next, Mike Hamilton is the co-founder and CISO of Critical Insight. He is the former CISO for the City of Seattle and former vice chair of the DHS Government Council. Frequently quoted in major media like the Wall Street Journal, New York Times, and SC Magazine, Mike is an in-demand speaker and educator leading our free monthly security awareness trainings. Mike also leads the nonprofit Pisces, which provides no-cost cyber monitoring for small local governments and uses collected data to train the next generation of cyber analysts at 20-plus U.S. colleges and universities. Next, Fred Langston is the co-founder and chief product officer for Critical Insight, a pioneer in InfoSec with over 2 decades of experience. Fred was the author of the HIPAA security rule. With over 24 years of professional information security experience working on thousands of clients, he has created effective risk management strategies, enterprise security, and data protection programs. Also an in-demand subject matter expert, Fred has been quoted by several of the nation's most trusted editorial news outlets. And with that, I will hand it over to you, Mike.
Okay. All right. So this is a topic I got to say that I have wanted to, pull some people in to talk about, because this thing really bugs me. And I understand, the reasons that we have litigiousness. First of all, let me just say that, the title of this is protecting yourself from class. It's not really protecting yourself, but lowering the likelihood that you will be exposed to a class action is not really a good title. But that's really what we're going to talk about here, is lowering that likelihood. What kind of steps can you take to avoid litigiousness? We are a litigious country, and this one has taken off and become an industry into itself, right? The class actions now that follow unauthorized disclosure of protected records is happening nearly immediately. There are attorneys that are scouring for announcements that there have been unauthorized disclosures of records, and you can see these are all very recent headlines here. So, and it's not just hospitals, it's happening all over the place. In fact, there was class actions that have been levied against some universities, as a matter of fact, for losing records. So it's not just health records, but the healthcare sector is the one that's really being beaten up by this. And to me, it seems absurd that after there has been a loss of records, which is a foreseeable event today, right? If there were $8 trillion globally lost to cybercrime in 2022, a number that is going up, that made it the third largest economy in the world. It's not coalesced into a single organization. It's very distributed, but statistically, that makes it the third largest economy in the world. And you are not going to go glove to glove with the third largest economy in the world and come out on top. So this is a foreseeable event. They're out there looking for you. They are scanning for vulnerabilities the minute a patch is announced, and they're coming. And so after there is this disclosure of records, possibly they're being extorted for this. And if ransomware is involved, this becomes double extortion. And then right after that, they've got to pay out. They probably paid a ransom. They are going to be fined by HIPAA. the Federal Trade Commission may come in with a False Claims Act, and then comes the class action. And we are suing our hospitals out of business. We're doing this ourselves. We're taking a baseball bat and beating ourselves in the head with this. Now, again, we're a litigious country, and this is kind of the thing we do. But I think this one has spiraled out of control a little bit. Some class actions I actually don't take issue with. So if those insurers are being sued for deploying advanced technology to deny claims, first of all, way to step up to the AI plate there, Humana, Cigna, United Healthcare. But if that's the way they're using technology, I can see them. Maybe I'm a plaintiff there. I don't know. Okay, so here's some definitions from the California Consumer Privacy Act. And the CCPA was the first state-level statute regarding unauthorized disclosure of privacy information. And so here are their definitions of personal and sensitive personal. There's not a lot of distinction between these. But the sensitive personal information has a lot to do with your communications, things that you don't want disclosed, secrets you want to keep, whereas personal information is your social security number, fingerprints, things like that. The reason I bring California up in this is because California has led the way in things like this. And this started with Fred, I think it was Senate Bill 1386. Was that 1998, somewhere slightly before 2000, where state of California came up with the definition of personally identifiable information, the combination of public and non-public elements of information that in aggregate have the potential for financial and other kinds of fraud. So your name, no good. Just a social security number, no good. But together, that means something. So that became the first data breach reporting statute, and now it's been replicated in 50 states. And we know that when there's unauthorized disclosure of records and it affects people that live in multiple states, there is a real hill to climb to do the required reporting and make sure that you're monitoring people's credit and everybody gets the right kind of communications. So this is California leading the way again on this. And the California Consumer Privacy Act is the enforcement of it is super expensive. They want a fraction of your company's revenue. So this is definitely something to be aware of. So let's talk about what got us here. First of all, California got us here, but at its base, this is what got us here. It's the ad industry, okay? And you probably didn't expect anybody to say that, but we are a capitalist country. And our job as inhabitants on Earth and the global economic system is to buy plastic stuff that we put on our lawn at Christmas and then send to a landfill. And we keep doing that over and over and over. We are the world's consumers, and consumption has always relied on advertising. Even back in the 1950s, advertising was the focus of a lot of sitcoms, right? Dick Van Dyke worked for an advertising agency. I think that Bewitched, Darren Stevens, I think he worked at an ad agency, right? So it's like we've always been exposed to how important the advertising industry is. However, with the advent of the internet and the ability to do creepy tracking, all that got away from the lawmakers. Nobody understood it, and we got to a point where the surveillance advertising, which is a term that's used a lot now, is the norm. When you're online, everything you do is being watched, and it's being aggregated, and it's being resold in a lot of cases to data brokers. And because of this, Congress has now taken this up to create a national privacy statute, which would supersede 50 different state statutes. Not all 50 states have statutes yet, but they're all working on it. So cynically, I will say that one of the reasons Congress is approaching this right now is not because consumers are, screaming bloody murder about all the tracking going on, data brokers reselling people's information, police departments circumventing the warrant process by just going and buying location data from data brokers. It's because Congress found out that Congress can be tracked just like everybody else. And so now they're taking this up. So it's going to be a tough hill to climb because the advertising lobby is really well equipped to coerce Congress to get what they want. So again, that's a little cynical, and you can see the picture there, how effective advertising is at convincing us to buy things that kill ourselves. Okay, here are the states that have consumer privacy laws. And some of these are called comprehensive, some of these are called narrow. And so you can see the difference between those here. Comprehensive applies to everybody that collects any kind of information. And it's if you are a construction company and your marketing website is collecting creepy information, you're included.
So, Mike, interrupting here for just a second. Aravind, I believe that Orrick, the law firm you're with, has a CCPA readiness product. Can we dive into that just for a second?
Yeah, so when CCPA came out a couple years ago, we built essentially an assessment tool that organizations can use to answer the question that Mike is asking, which is like, if you are a construction company, right, even under a comprehensive bill, you may not be subject to it. There are thresholds in terms of how large you are, what business you're in, whether you sell data, whether you don't sell data. And so we built, at least for CCPA, an assessment tool a couple years ago, which you can get on our website and you can go through. It's a quick set of questions that you can answer. And once you answer those, it sort of gives you a report and says, here's some things you ought to think about. And then that actually can get you a free consultation with someone on our team. So if you're interested, you can do that for CCPA. That's often a good jumping off point to the point that Mike makes to talk about other comprehensive bills or statutes in other states, because they're all in some way, shape, or form modeled off of California. They're not all the same. They have different definitions, they have different applicability and so on, but it's a good place to start and get a sense for, like, if I'm need to comply with California law, I probably have some others that are also in scope.
Thank you.
Yep. So the narrow laws, conversely, talk about very specific aspects of the economy where they're trying to control data collection. So especially we're trying to govern these data brokers, right? These, when you put an app on your phone, that app can do a lot of things in the background that you have no idea about. When you click OK on that EULA, right, the end user license agreement, without reading it, you're giving a lot of stuff away that you probably don't want to give away. So the apps on your phone will report your location, and they will surveil some of the things that you do online. Just like if you go to a web page that's all hooked up to, marketing products, they know who you are. It is amazing the amount of information that can be gleaned that way. And as we all remember, a lot of hospitals got in trouble. And I believe, and Aravind, keep me honest on this, I think there was a class action suit about this too, about the tracking pixels that were used on hospital websites.
Yep. Yeah. Yep. And in fact, they're probably, just related to hospitals and healthcare organizations, there are probably more than 100 lawsuits that were filed on whether they use, and again, it's not just limited to pixels, and just to be clear, it's limited to any kinds of technology they use on their website and don't disclose, because they arguably violate, among other things, the HIPAA privacy rule and just general state privacy laws.
Yep.
Aravind, wasn't there a federal judge that put an injunction last week on enforcing the pixel tracking component? I know there was a big something happened last week.
Yeah, I mean, what I would say on the pixel tracking pieces, I haven't seen that one, Fred, but there are decisions that go both ways. That's suffice to say, there are judges who think that these cases are garbage and are tossing them. And there are judges who are letting these cases go on through the early stages of litigation on to discovery. We think all these cases are garbage. They're sort of ridiculous. And the newest species of them under 63851 are even worse. But suffice to say, I think it's a hodgepodge and a patchwork across the country. And I think that it's going to take a little while before an appellate court gets its hands on one or more of these cases to actually make some good case law here, hopefully, that these cases are really just garbage.
Yeah, that's interesting. I read that too, that there was an injunction, and it didn't use the word garbage, but I'm glad you did. Moving on. So the narrow laws really apply to these insidious data brokers, but also your ISP. Your ISP knows all kinds of stuff about what you do, and right, that needs to be protected. Okay, so why are the state laws all coming out here, and why is there no federal law? So first of all, I'll use the example of New York State. So in New York State, their Department of Financial Services, right, DFS, and also their state equivalent to Health and Human Services, which I just think is called their Human Services Department or something like that, have both. The state of New York has created laws that regulate those two, finance and healthcare, much like the FFIEC does at a national level and Health and Human Services does at a national level. And the reason, in my view, that New York has done this is to get away from Congress going back and forth on things and never being able to get anything done lately. So, you know, a dysfunctional Congress that can't get laws enacted, and a political system that when the wind blows the other way, a law that was there may be going away. And the example of this is what's going on with the sector-specific regulating agencies, like Health and Human Services regulates the healthcare sector. The EPA regulates water, for example. And the EPA was just sued when they tried to add, through the rulemaking process, a regulation for water sector that said, well, when you do your sanitary survey, we want you to do a cyber risk assessment and submit that as well. And 3 states sued, and so they had to back off of this. And now a lot of this regulatory rulemaking with the sector-specific agencies, so for example, the TSA regulates pipelines. So they give guidance to pipelines, and that guidance turns out to be regulatory, and now that's all pulling back. So like I say, Congress, if they could get something done, it might end up going away. So the state laws are coming in to circumvent that. And this has clearly created a patchwork. You saw on the preceding slide, some states have comprehensive laws. Some states have very narrow laws. Different states have different variants of these. None of these are identical. And so if there is an unauthorized disclosure of privacy information, and health records are privacy information, it's going to be really, really hard for that organization that's been impacted to comply with all of these laws. It's tough enough with the data breach reporting laws that are in all the states. Now this piles on top of that. So it is a patchwork. Congress is working on a national privacy statute. Whether or not that's going to see the light of day, it's anybody's guess. But in terms of not so much legislation, but executive orders, the Biden administration came out with the National Cybersecurity Strategy. And one of the elements of that is devaluing data that gets stolen all the time. So these records. So how do you devalue that is you limit the collection of, you know, what advertisers in particular, but all kinds of other organizations as well, limit what you collect. And one law that's just been revised to be very specific about that is COPPA, the Children's Online Privacy Protection Act. And they widened the definition you see there of personal information to include tracking cookies. Okay, that's progress, right? So that we don't want this stuff collected in the first place, because if you don't have it, you can't lose it. So there is a little bit of progress being made there. Really at the state level, the feds are trying. However, it's been proposed. It has not really gotten out of committee yet. There are co-sponsors. There's bicameral co-sponsors. There are bipartisan co-sponsors, and still they can't seem to get it out of committee. But there are 2 key terms here So there are more than a few obstacles to overcome, including the same challenges that were evident in 2022, such as state law preemption and private right of action.
So talking about private right of action, Arvind, can you unpack that a little bit for us? What exactly is it?
Yeah. So, I mean, the way to describe it is to say this, which is statutes can either create a right for regulators to enforce a violation of those statutes. So, for example, if you violate the HIPAA privacy rule or the HIPAA security rule, only HHS OCR can pursue you. However, there are other laws which create a private right of action, which allow individuals to bring lawsuits alleging a violation of that, right? So CCPA is a good example. For the first time, we have a statute that says if you don't follow certain security requirements, there can be you can bring a private right of action, and there can be a fine of anywhere between $100 to $750 per person. So the private right of action allows individuals to bring those cases, not just regulators. And you can understand how the plaintiffs bar really wants to have those rights because that's how they make money. And the states are conflicted in many respects as to whether or not they want to enforce their own rules, right? Whether it's a state AG or NYDFS, or whether they want to essentially imbue private litigants with the ability to police the market.
Right. And in a litigious society, everybody can be a plaintiff. Okay, so it is in question as to whether or not and or when we will get a national privacy statute. It hopefully is in the works, and it may curtail some of this if they can withstand the lobbying that's going to come from the ad industry, and do this state law preemption so that we don't have a patchwork anymore, and private right of action so that individuals can't sue.
And with that, isn't there some necessity to have some demonstrable harm for the plaintiffs to have standing?
Great question. That is a great question. Arvind, you want to take that?
Yeah. So standing in, let me go forward for a second. So there are two real hallmarks in thinking about standing. One is whether the individual has been harmed by that conduct and whether that harm is traceable to that conduct. And so both of those tend to be problems in data breach class actions, right? As we know, bad guys steal lots of data. They don't always do bad stuff with it. Sometimes they're just holding it for ransom. You pay the ransom and they claim to blow it away. And so whether or not an individual suffers harm, they actually have to suffer that harm and it has to be traceable. So a lot of times we get cases where individuals say, you lost my data. I spent all this time trying to get credit monitoring and doing this, that, the other thing. Well, that's all fine, but that may not be actual harm that you can get standing to stay in court on. And you have to have that certain type of harm in order to be able to stay in court. You also have to have that harm to be able to be traceable to that event. So for example, a lot of times what we do is we can go and do some research and figure out, Aravind Swaminathan has been involved in 17 different data breaches. And I can go on the dark web and see that his data was stolen in this incident, and that incident, and this incident, and that incident. Well, so then how do I know that the harm, even let's just say you're the victim of identity theft, was actually traceable to your incident or somebody else's incident? Because my data has been stolen God knows how many times. So both of those are arguments that you can bring. And if you can demonstrate that there's no harm or that the harm's not traceable to the actual event, right, you can go to the court and say, you ought to kick this case because the plaintiffs here don't have standing to actually bring these claims. Now, in reality, just as a footnote, that's a great argument in federal court, if that's where your case happens to be. But oftentimes what that ends up is they say, fine, we'll dismiss out of federal court and go sue in state court because the standing rules in state court are much, 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 much lower. And so there's a debate as to whether or not you actually want to even make these arguments, because all it does is you end up in state court. And for many states, I don't want to be in state court. The judges aren't as good. The standards are lower, right? How I'm going to win this case is going to be much more difficult. I might want to stay in federal court. So even sometimes where you don't have standing, you may decide, I'm going to still stay where I am and not raise this argument right now in this context. and then wait and bring these arguments forward at a different stage of the litigation. So it doesn't mean that they're arguments you lose the ability to argue. You're just not arguing them it's to standing. You're making that point on a different basis, right? As to whether or not you're responsible, whether there's causation, that sounds like traceability, whether there's harm, it sounds like a summary judgment motion. And so there are different strategies to using the same arguments. And we debate sometimes whether or not we want to use them early or want to use them late.
I'd like to talk about the economics that drives this, because while you can certainly talk about how you might win or defend against this in court, the reality is there is a ton of automation out there that the class action world of attorneys use to gather up information as rapidly as possible. They immediately begin as it's a race to contact the potential victims and start having them join the class that they're trying to build for the suit. So you have maybe multiple classes being built during a process right after a breach. People are being contacted, joining these, and then potentially they know at some point these classes will be joined together, probably in a master class action lawsuit. Well, if you're a healthcare entity, it's much easier to go out and say, let's just negotiate a settlement. Let's not go down the road of defending this ad nauseum. So the economics of this tends to drive not so much the legal statute building that would be really useful, but probably more, I'm just going to move forward. We're going to put this behind us as rapidly as possible and make these class action lawsuits go away. So it's becoming a tax on doing business in this space.
So that's all that's right. Let me give it a little bit more flesh on the bones, Fred. So a couple things are true. One is you don't have to automate figuring out this anymore. If you just got to go to Maine's website. Maine requires organizations that have to notify the Maine State Attorney General to tell the Maine State Attorney General how many people, not just in Maine, but in total, were impacted by this. So you may have 50 Maine residents that are impacted. You may have 1 million total. So you don't have to tell Maine just 50. You have to tell them the 1 million. They post that on their website within moments of you doing it, and it's out for the plaintiffs to see. So candidly, every time there's a breach, right, and there's a notice about the breach, just go to the Maine website and figure out how many people were impacted. So the plaintiffs can then very quickly filter out which cases they want to pursue and which cases they don't. The next step for them is to say, great, I'm going to launch a social media advertising campaign and aggregate plaintiffs and come to me. They don't go seek them out. They basically say, hey, this happened. If you happen to have been a user of this service or you bought this thing, right, you may have a claim. Click here, fill out this form, and then they can sift through those and figure out who their plaintiffs are. So then the question becomes, Fred, which is a good point. These cases don't go to trial, period. Like, a data breach class action has not gone to trial in my lifetime, right? And so the question then becomes, all of these cases either you get disposed of them by litigating those cases, or you settle them. And there's a threshold economic issue here, which is at certain lower numbers, 300, 400,000 records, it's not economically efficient for a company to litigate the case. Because by the time you get to a point in litigation where I can win the case, or maybe have a chance to win the case, you've spent $2, $3 million, $4, $5 million. And so then you say, like, well, wait a minute. If I just take that $2 or $3 million and pay the plaintiffs, I'm done. So I don't have to pay Aravind. I can just go settle the case and get like an assurance, get certainty around what my risk is. And so candidly, if their case is 3, 4, 500,000, like for a lot of those cases, they're worth settling early because it's just economically rational. Now, not saying that it's zero. I mean, it's a lot of money, right? And we can get into the insurance piece later. But the point is that these smaller type classes aren't efficient to litigate. And so we settle them oftentimes very routinely. Like we've settled cases in 45 days, right? We just go to the plaintiffs. We say, here's what this case is about. Let's give you some early discovery. Let's tell you what it's about. Let's get into a mediation. And let's get the case settled and resolved. That way, clients are not paying both the plaintiffs and the plaintiffs' lawyers and me. That's a meaningful savings that they can make, right? And you get certainty on what your risk exposure is, right? So you're 100% right, Fred. There are certain numbers at which that makes sense. Too large, 2 million, 3 million, 4 million, just do it on this basis. If you're thinking like $5 a record and it's 4 million people, well, you're not selling that case for 20 million. You're gonna have to litigate that case a couple rounds before you can get to a place where you have a better leverage to actually go get it resolved.
So Aravind, can organizations be plaintiffs in a class action? Because they can definitely show some harm.
They can, but it's more complicated. So you'll remember that all the banks got together, I think it was after Target, and sued Target, right? And the theory there was that the banks were all harmed because when Target lost all those credit card numbers, the banks had to go actually, A, they had fraud charges on those cards, and B, they had to reissue all those cards. And so Target's breach caused that harm. And so the banks all got together in a class and sued Target. So that still happens. It's rare. And the reason it's rare is because the reason a class action design is designed to defeat what's called the collective action problem. I'm not going to sue by myself because it's too expensive for me to sue by myself when I'm only going to recover like $100 or $200 or $500, right? And so that's a collective action problem. The class action mechanism is designed to solve that problem. And it's really meant for individuals where what's happened to them is typical of everything that else happened to everybody else. With organizations, it's not typical, right? Organizations are much more complicated. There's much more factors. There's contracts involved, or sorts of things. And so at the end of the day, it is theoretically possible, Virginia, to do that, but it's very, very rare.
All right. This is I knew having a kick butt attorney on here was a good idea. Okay. I think this is where we dropped off, and I'm going to continue here a little bit, and then I'm going to hand it back to Aravind to talk about some more legal things because I know I have some questions, and there's probably going to be some questions coming in the chat. This is a lot of class actions. And it looks like the rate is very rapidly increasing. So we see that the threat, which is a combination of nation state actors that pretend to be criminals and straight up criminals, is getting very vigorous out there. It's hospitals are targeted because in terms of, ransomware and extortion, they're probably going to pay because if it's ransomware, they can't be rendered inoperable because then the patient outcomes start to go off a cliff very quickly. But B, if records are held in abeyance and they're being extorted for the records, if you don't pay them, those will be made public. You will get a class action suit, possibly get the FTC coming in with the False Claims Act, things like that. So here are the kinds of things that are extant in my review of the class actions and what has been said, right? What the complaints are. So it's definitely the number of individuals. It was kind of data. What is the nature of the organization and the industry? And do they have a history of data breaches? So all of those kind of go into making it more likely that you're going to get sued. To Aravind's point, if there's 3-4 million, or in the case of United Healthcare, what is it, 100 million, a third of the country, that's going to get crazy. You're really going to be more likely to suffer through this litigation.
Yep.
And I can't think of another industry that is at the same risk as healthcare, possibly schools.
And I think that, Mike, so I would say financial services and healthcare are probably the two most sued organizations.
Yeah.
But there's some good reasons for that. There's not some good reasons, but there's a reason for that. The reason ultimately is with healthcare organizations following Anthem, the belief was that information is more valuable than other sorts of information, other than what financial organizations keep, which is bank accounts and social security numbers, right? And so the permanence of the information in both those two industries bears on the relative desire to sue those organizations. The other things are the financial industry has money, right? And so don't go sue some tiny little company. That's really not worth your while as a plaintiff's lawyer. And almost every healthcare institution has insurance, right? So the plaintiff's lawyers aren't stupid. They're not going to go waste their money suing a small mom and pop's pizzeria. Like, that doesn't make any sense. Even if the pizzeria lost 1 million records, they don't have a whole lot of money to pay you, right? A settlement, they don't have insurance. You're trying to get water out of a rock. That ain't going to work. But because healthcare and financial services are also the most well insured or most often insured, right? They're good targets to go after, right? There's a bunch of other reasons to go do that, but oftentimes it relates to the industry focus, relates to the kind and quality of data, the number of records that they have, and also like the fact that they have deeper pockets than others.
So Fred, do you know of circumstances where, never mind, I'm not going to ask. We'll wait till the questions here. Okay. Moving on. So what are the complaints that we see typically when we're seeing how these are being reported, right? So your organization did not take appropriate steps to safeguard my data. That one shows up all the time. There are other ones where the organization was asked to remove information, and because right now, like all the websites have, here's our privacy policy, and if you don't want us to collect this stuff, click here, pick the stuff, the cookies that we're going to leave behind, and throw out the ones you don't. If you're asked to remove stuff, especially following along the lines of GDPR, if you were unresponsive, that can cause a suit. Took too long to notify the affected customers, patients who are now plaintiffs. This one shows up all the time too, and I can see how it takes a while to sort through this to be accurate about these things. The placeholder that goes up, on Health and Human Services wall of shame is 500. So they could put a placeholder there of 500, and they're trying to work through this. Well, if months and months and months go by, and then they start to notify people of this. Well, my record's now been out there for 6 months, and you're just now telling me this. That comes up all the time too. And then the public statements, we care about the security and the confidentiality of the information that you trust us to store. And if their practices are found to be inconsistent with those public-facing statements, that's where the Federal Trade Commission comes in, because that is the false claim right there. So it's these things typically show up in these actions. I'm going to give this back to you, Aravind.
Yeah. So I think we talked a little bit about the standing argument generally and how that can be a defense that you might want to raise in litigation. Again, the other one I would say mention is arbitration agreements and class action waivers. So many organizations, in developing a relationship with the individual, they have a term of service, right? If that terms of service, if that agreement is binding on the individual, and I'll talk about that in just a second, and you include a requirement to arbitrate certain disputes and an inclusion of a class action waiver, you can actually scuttle their ability to sue you in a class. Because what you say is, no, judge, this case has to go to arbitration. And by the way, they can't proceed as a class. They have to proceed as individual arbitrations, right? Now, whether your terms of service can bind them actually depends on how you get them to agree, right? If you get them like a bank and a depository agreement, get them to sign a piece of paper and hand it to you, that's easy. If you're relying on the terms of service embedded at the bottom of your website, not so easy. And there's actually some mechanics that you have to go through to make sure that they can see it, they have a chance to click on it, and all sorts of other things that we sort of a conversation for another time. But if you have, so that gets back to, if you have arbitration agreements and class action waivers that are binding, or you can argue are binding on the individual, you can take them out of litigation in the class context, force them into an arbitration on an individual context. And for the most part, plaintiffs' lawyers don't want to pursue those. It's a lot of work to individually arbitrate Mike's case, and then Fred's case, and then Arvind's case, and then Virginia's case. And it's more work than it's worth, right? Because they're only recovering $500, $1,000 a pop, and they're only making like $300 at a time on a contingency fee, right? A percentage. And the hours that they have to invest to get a very small recovery, you go back to, now you have a collective action problem. Footnote, there is something called the mass arbitration, which I'll just mention really quickly. It's a strategy that plaintiffs' lawyers have come up with. In many arbitration agreements and the way the rules are set up, the company has to pay a certain fee in order for an arbitration to be instituted. Those fees can be $4,000, $5,000, $3,000. So as a plaintiff lawyer, I say to you, company, hey, I know you have an arbitration agreement. I have 3,000 clients that have been aggrieved by this. I'm going to institute 3,000 arbitrations, knowing that you're going to have to pay $3,000 in arbitration. So that's a 9 million liability just to start. So settle with me for $4 million, and you won't have to pay that, and we can all go away. That is not a class action. That is I have a bigger gun than you do, right? Kind of extortion racket that the plaintiffs run, and it's dependent upon there being an arbitration agreement. Longer story, there are defenses to that. There are ways to address that, but just saying, oh, we have an arbitration agreement is not enough. So it's a more complicated conversation, but it can be a very useful thing to do today, or at least consider today, that can help forestall the risk of class actions, by the way, both in data breach and in privacy, like we were talking about before. So that's something you can do ahead of time. There are things that you can do after the fact, right? So if you want to make arguments around, does this court actually have personal jurisdiction over me? Probably less really relevant to most of our healthcare clients, right, who are in the US providing services to individuals. But we have lots of companies that are not here, that are outside the United States, that collect data and are losing that data. And we argue, fine, but you can't sue them here, right? So for example, we won a number of motions to dismiss, saying to the court in California, you're not authorized to adjudicate this case here. You don't have what's called personal jurisdiction. You can't hail those people into court. And we've gotten those cases dismissed, right? Again, for a cross section of companies that are based out of the United States or based in other jurisdictions, right? That's one you can go through. And again, there are substantive defenses. Like we argue that negligence is precluded by the economic loss doctrine. So there's a whole series of substantive defenses that we can raise in defending class actions. And all of these are at the onset of the litigation. This is at the beginning, right? And so if you can win some of these, you can get yourself into a better negotiating posture. If you win all of these, you might be able to get the case kicked altogether. If you don't, then you have to proceed through the painful process of discovery and more litigation until you actually get to a resolution.
So Aravind, that was eloquent and beautiful, but can you take it to explain it to a fifth grader level for me?
Yeah, but here's what I would say. Probably 2 or 3 things you can do today, right? In your agreements, in the way you develop your relationships with your customer base, right? That's stuff you should consider doing today to mitigate your risk. When the incident actually happens, depending on the facts, you maybe argue that these people don't have the right to sue you in the court that they're suing you in or at all, right? That's bucket 2. And then bucket 3 is substantively, are these claims that you can even bring, right? Are you able to what we call state the elements of a claim? In other words, have you been aggrieved the way you say you have been aggrieved in a way a court can rule on?
I still think that's above fifth grade, but I think that's great. Thank you.
I have a question. Is there a statute of limitations involved? Because let's say criminals grab records and we extort an organization, and placing myself as the criminal right now, I extort an organization and I have all of these records and I say, okay, you paid me, I'm now destroying these. There is no verification that they've been destroyed, and they could still show up on, to your previous point, this is durable information, right? It doesn't go away. I mean, you can change a credit card number, you can't change a DNA. So these could potentially show up for sale on the dark web sometime later. So is there a statute of limitations? So
there are statute of limitations defenses, but they're all largely obviated by this fact. The statute of limitations typically runs from the moment that the individual who is hurt knows that they have a claim. When do they know they have a claim? When you send their data breach notification letter. When do they sue you? Right after that letter. So that problem has largely been obviated by the need to have notices. Let me say it a different way, right? If somebody stole your data 5 years ago and you don't know about it, and then all of a sudden it shows up on the dark web and you start getting identity theft, that's when your claim accrues, right? That's when you have a claim. And so you can bring that based on, and so then if your statute of limitations, you have to bring it within 2, 3, 4 years of that time, right? To the time they stole it, from the time that you know that you have a claim. That's what it's designed to do. And so you know you have a claim when the company notifies you. And so from then on, so yes, if you tried to bring a claim against Target today, you're kind of out of luck, right? But the answer is because because Target notified the world of the incident, nobody really has a statute of limitations problem. And again, plaintiffs' lawyers are the ones that are driving this, and they sue you immediately. So that's obvious a statute of limitations problem.
Okay.
So I have a question that about Change Healthcare, which is probably going to end up being one of the largest class action breach suits ever. I would suggest that this is maybe an exact example where an organization may have standing, because there are hospitals that went out of business, literally, because of this breach. Do you think is this something that could maybe change things? And is this the kind of thing that actually might go all the way to a decision?
So I won't comment specifically on Change Healthcare because I gotta be careful.
I understand.
But as a general matter, here's what I would say, which is when there are real cognizable harms and when there's a real motivation to actually sue and pursue it, yes, it can create, like Fred, what you're sort of describing is like existential risks to the business that force litigation to go all the way. But what I will tell you is that still hasn't happened, right? We've seen massive data breaches happen and no one's taken it all the way, right? Like today you're focused on Change, right? But Anthem wasn't that much different, right? And there's a whole number of incidents that we've seen where the number of records compromised are in like over 100 million. And so I guess what I would say is I'll believe it when I see it, because the stakes are too high, right, on both sides, and there's risk, right? And what everybody wants in litigation is certainty, period. And if I can get certainty by settlement, I'm going to be motivated to find a way to settle a case so that I can get that certainty. Maybe it's not at the beginning, maybe it's at the middle, maybe it's close to the end, right? But the reason cases settle in the courthouse doors is because you lose control and people don't like that. They want certainty, and so they're willing to settle.
Okay. So key questions. So what are some of the mistakes that organizations make? Well, I think if we say, well, they don't like the fact that you took too long to tell everybody about this, your controls were not in place, et cetera, some of the things that we discussed before, those are the things you address. You know, you make sure that your incident response process in a situation like this, you're being extorted, has somebody really good at communications on the incident response team. I would say too, and there are some interesting laws coming out of places you wouldn't expect, like Florida. Right now, Florida legislature is looking at a law that would provide safe harbor if you can, from regulatory pressure, or sorry, from civil action, if you can demonstrate that you had controls in place that met a standard of practice. So that tells me you would need, auditors to come in and examine this. It can't be a self-assessment because that's, aspirational a lot of the time. That's the kind of thing that you can do before something happens, so that later you have, your papers that you can show and say, look, we said we were doing it, and here is the proof we were doing this. I would suggest using something like the NIST cybersecurity framework, lining yourself up with that, making sure that you have artifacts that demonstrate that those controls are in place. It's outcome based. It's not that hard to do. That would be one way. What are some of the other ones? On the other side, after something has happened, that's when your communications got to kick into gear. That's when you got to be ready, because the litigation attempt is coming. Yeah. And so I don't know what else you can do after it happens, except be ready and take some of the advice that you've given everybody, Aravind, about when to settle, what to do in the initial stages of the case, things like that.
Yeah. So there are a couple things I think we haven't talked about yet, which is, I do think what companies say or organizations say about their security publicly and representations that they do make are sometimes the petard that you get hung up with, right? I think it's easy to say, we have bank level encryption. Well, first of all, I don't know what that means, or military grade encryption. I don't know what that means, but putting that aside, right? You don't need to say that to communicate your commitment to security. And you set yourself a standard that I'm not sure you can get to. Look, as a litigant, as your counsel, I will argue that that's garbage. But at the end of the, that's not really what that means. But at the end of the day, what you say about security has to be carefully vetted against what you do. It's the same thing in privacy. If you say you do it, you better damn well do it. So that's number one. I think it's worth going through, and audit is too strong a word, but at least go back and review what you've said about your security of your system and make sure it matches what you actually do. That's the first thing you ought to do. The second thing you ought to do is, this is easy to say, but data minimization is a hugely valuable strategy. You don't have to protect what you don't have, right? And if you don't have it, you can't lose it, right? Or at least if you go and put it in cold storage where look, if I need it, I'll go get it, right? The same thing is true with encryption and all kinds of other things. But again, data minimization is the easiest step to take, and to say we don't need this where it is anymore. These patients haven't come to the hospital in 20 years. If we need to go get that record, we'll go get it, but we don't need it live on our system, and reducing the sort of the attack surface. So that's number two, I would say, in addition to the things that we've already talked about. I think, Mike, the point you make about, so I think if you go pre-incident, these are just some of the things that you can do, right? I think all things, Mike, you said are also great things to do. Although, look, we do that all the time, and we tout that and we push back on plaintiffs' lawyers. We still get sued, right? There is you lost my data, you must be insecure part to all these cases. It's sort of like an ipso facto thing, right? I know that's not fifth grade. I don't speak Latin, but it basically means well, you got breached, so you must have been insecure. I know people say that a lot, and you're not supposed to, and the law actually says that that's not enough, but people do that. So I think what you then have to do is flip to, what are you doing during an incident? And I do think that one of the most important things that clients get wrong time and time again is how they're going to communicate with stakeholders about what they did, what they know, what they're doing. You can't stop the fact that you're going to have to notify Maine and tell them 1 million people had an incident. But you can avoid a foot fault by making sure your notifications are crisp, clear, and have the appropriate level of transparency, that you have put into place a way for people to get credit monitoring. All those little things, they do matter, right? I'm not saying this moves the needle and says you're not going to get sued. All I'm saying is you oftentimes get judged by what you do after an incident, as opposed to what happened and the fact that you've been hacked. And you got to remember that, especially, Virginia, to the question you've asked, which is thinking about your partner stakeholders who are impacted. If you're really a third-party service provider, the last thing you want to have is your customers suing you. Well, that's something you can manage after an incident, right? You can't manage the plaintiffs' lawyers and the individuals, but you might be able to manage your business partners. And so you really got to think about that and plan for it ahead of time.
I want to extend a little bit about what you were saying about understanding the breach, because one thing that we find all the time is people do not have their auditing and logging systems set up to do rapid analysis of actually not just what happened, but who it happened to, because that's who your class is going to get built. So if you don't have that ability to determine quickly who are the people that are affected, you're not going to be able to communicate. You're not going to be able to plan your legal strategy or your communication strategy. And if you end up Change Healthcare, which one of their biggest problems was they could not eventually determine exactly who was breached. So you have to say everyone that was in that system. Right. Now we have to report as being breached, because we don't have the ability to go in and figure out exactly who it was.
Look, so we can talk about data minimization as one part of data governance, which is part of what you're talking about, which do I actually even know what data I have, where it is, what it is, and what form it is, right? If you're going to go do, and we had this happen, you're going to go do some reporting on all of the anesthesia patients that you've treated over the last 2 years, great. But why do you need to keep those PDFs of all those records a year and a half after that analysis is done? That's about data minimization, but it's also about do you really need to keep it in a PDF? Can we put it in a database where it's much easier to, if you need it, put it in a database where it's much easier to query and understand what those records are? Because if it's in a PDF, you know how painstaking it is to go through those PDFs and figure out what data is there. That's one thing. I think the other thing is quantifying how you are logging your own security system. So that's a slightly different thing, similar, but visibility into your own network is critical, right? So that I know, look, I can tell where the footprints go. I'm not blind in this corner of the organization because we have audit logging turned on, right? So I think understanding where your most valuable data assets are and making sure that you are logging that stuff appropriately is really critical. So if you have a shared drive, which lots of people do, right? An appropriate level of logging on the shared drive so you can tell what was accessed. Like I can't tell you how many companies that saved, which is like, look, they've got 8 million files in their file share, but we have audit logging turned on. And over the period of compromise, we can tell exactly which account was used to access which of these records. Doesn't save you from the breach, but you're not reviewing all 8 million files. You're down to 2 or 200, right?
Yeah. And so, I mean, the converse to that is if you don't do those things, the incident response team that costs $400 an hour per person is going to take a really long time to figure out what happened. And boy, that's just going to ramp that cost up too. Okay. So that's all of that. I have another question too. And this is about, so I was actually contacted by a class action attorney on the East Coast who wanted me to search the dark web for children's records. Okay, so like out of the gate, that's just creepy, right? And was trying to find if these records had been exposed. But the question to me comes up because children's records are very valuable, mostly because they have pristine credit histories and they can be abused in fraudulent ways for years before people find out, right? Before anybody knows they're victimized. Is there a special case for children's records? Is there special penalties? Is that viewed differently by the courts?
It's so the answer is generally no, right? But where the impact is heavily on the side of children, we see the plaintiffs' lawyers ratcheting it up, right? And so whereas they might say, oh, you lost, 1 million records, it's $5 a record, you lost 100,000 kids' records, we think that should be $20 a record. So it goes into how they value their case, Mike, and how they'll think about settlement when you have a high density of children.
Yeah.
Footnote, just for what it's worth, is oftentimes by the time you've lost the data, those children aren't children anymore, right? I've come to that problem all the time, where, especially with healthcare, which is like, we've had those records for 10 years. She was a 10-year-old at the time. She's now not a 10-year-old, right? And so, not that I'm saying you want to be in that situation, but oftentimes that is an artifact of when you have data for a really long time, kids grow up, and so oftentimes they're not children anymore. So I just make sure you understand that before you just head into a situation where you're notifying individuals or you're defending in a class action.
So real quickly, before we all go our separate ways, I did want to remind everybody that we do provide a complete set of cybersecurity services, from preparation, certainly getting ready for breaches, understanding to have these processes in place ahead of time, finding malicious activity as it's happening, critical. The faster you can respond, the easier you can limit that impact, and the speed in which you respond and recover. All of these are critical to the discussion we're having today. Virginia?
And please stay connected with us. We'd love you to sign up for the daily IT Security News Blast, which is curated by Mike Hamilton and has been for the last 15 years. You can sign up for that on our website. We'd love it if you'd take our survey. That's there in the chat for you. We also give our free monthly security awareness trainings online. So please go to our website and you can sign up for the next one. We do offer regular online urgent panel webinars and podcasts. And you can learn about our nonprofit partner, Pisces, at piscesinternational.org. And please, if you've had a nice time today, we'd love that you've come back again next time. Sign up for our emails. Final thoughts. Mike, I'll start with you.
My final thought is this. There are no records left to steal. Everybody's had their records stolen multiple times, and it's being very difficult these days to deconvolve which one of those events possibly is what you were talking about traceability, Aravind. I think the situation is so out of control that we've got to do something to tamp down this additional beating that we're giving ourselves. And I think the way to do that is through a national privacy statute. And so, come on, Congress, get it done.
Fred, final thoughts.
Yeah, the bad guys now will reach out and contact patients. They'll contact regulators. I expect the next target, class action lawyers. Wait, I'm making that prediction. That's coming.
I might cross my fingers for that one. I think all I would say is like this problem is going to get, unfortunately, like to Mike's point, worse before it gets better. It's not hopeless though, and I really do think if you're facing down the gun of litigation, what's most important is that you have a really thoughtful strategy around whether you want to fight or whether you don't want to fight. And I don't think that that's an easy conversation, but I do think it's critical to like deciding how you want to approach the situation that you're in.
Thank you so much. Thank you, everybody, for joining us today. Thank you, Aravind, for joining us as our special guest. Have a great rest of your day. Take care.
Thanks.
Thanks everybody. Thanks, Aravind.